After two Sacramento police officers killed unarmed Stephon Clark, Assembly members Shirley Weber and Kevin McCarty are pushing a bill they hope will curb police shootings.
This policy authorizes police officers to use deadly force only when it is necessary to prevent imminent and serious bodily injury or death.
If this passes, California will allow jurors in criminal cases against police to look at events leading up to lethal force instead of only considering the split-second decision officers often have to make. That quick decision can mean life or death for officers in situations like this.
Take your hands out your pocket! Shots fired!
It's also what jurors use to decide if an officer's actions were objectively reasonable. This phrase has been embedded into police shooting cases since the 1989 Supreme Court case Graham versus Connor, giving police protections from being charged in many on-the-job shooting incidents. According to the California Department of Justice, between 2005 and 2016, only 2 police shootings that resulted in death were not justified by law.
This bill establishes that it's not enough that the officer perceived a threat. There had to have been no other alternatives to using deadly force.
The Los Angeles Police Protective League says if this bill passes, it will either get cops killed or allow criminals to terrorize our streets unchecked. Pick one. Activists hope the public outcry over the Sacramento police shooting will be the impetus for California to change its standards.
Well, I've been doing this work for well over a decade. This bill is many years behind when it should have been introduced. Not that I'm not grateful for the bill and for people trying to make movements toward police accountability.
Bills that law enforcement opposes rarely win approval from the California legislature.